friends, welcome back to our channel where we decode the most significant current affair topics for the UPSC Civil Service examination. Today we are exploring a topic that has been at the center of debates and legal reforms called subcategorization of SCs and STs, scheduled castes and scheduled tribes. This topic is crucial for your upcoming examinations, so let's dive deep into these implications and its relevance to UPSC. The subcategorization of SCs and STs is all about diving these communities into smaller subgroups. In other words to say, to understand this topic, subcategorization of SCs and STs is all about equitable distribution of reservation benefits. Equitable distribution of reservation benefits, ensuring that most marginalized within these communities receive the support they need. Why is this necessary? And what are the broader implications? Let's break it down. To understand this, you should have an idea that what exactly happened in 2017. Subcategorization is not a completely new idea. The states like Andhra Pradesh, Haryana have already experimented with it. However, in 2017, the central government took a decisive step for forming the Rohini Commission. And the name of the commission is very important for the examination. The Rohini Commission, which was formed in 2017 to access the disparities in the distribution of reservation benefits within SC and ST communities at a national level. And coming to this Rohini Commission, it was headed by Justice G. Rohini, which had worked diligently to study these disparities. Its goal is to ensure that subcategorization can uplift the most disadvantaged groups, the marginalized groups, who might otherwise be overlooked under broad reservation schemes. And this commission is expected to submit its final report soon, and its recommendations could lead to significant reforms at the national level. And hence, this so-called current affair topic is having its own relevance to UPSC syllabus, which is best fit into our UPSC preparation. Primarily, you will find it relevant for GS Paper 2 under polity and governance, issues related to welfare schemes for vulnerable sections of the population of India, and GS Paper 1 under the module society, where the discussions around the social justice, the affirmative actions, and the complexities of caste-based inequalities in India. And these two important papers is going to be the most relevant papers for this topic. So in this context, let us understand the current developments and why it is in news. And the current affair today is, in a landmark judgment, the Supreme Court of India has overturned the 2004 EV Chinnaya's ruling, allowing the states to subclassify scheduled castes and scheduled tribes for reservations. A significant development occurred recently when Supreme Court of India delivered this landmark verdict, which overturned the 2004 EV Chinnaya's ruling. And it has its own majority decision. All the 6 important majority decision falls under 6:1 is the majority decision. The court now allows the states to subclassify SCs and STs for reservations. And this constitutional authority is seen as a move towards greater equity. In distributing the reservation benefits to the most marginalized subgroups within these communities of SCs and STs. And based on this, you should also remember that there are certain implications and analysis of the Supreme Court verdict. And it includes the key implications like subcategorization is permitted. So the Supreme Court permitted the subclassification, through which it clearly stated that the states can now constitutionally subclassify SCs and STs to address differences in backwardness within the existing reservation quotas. Okay. Likewise, subclassification must be grounded based on the data and historical evidence. The data and historical evidence of the marginalization, which prevents the arbitrary decisions driven by political motives. And hence, it strongly said only on the empirical basis that the states constitutionally subclassify SCs and STs without having any empirical rational basis. The state cannot make the subclassification for the SCs and STs. Not only that, it also extended the creamy layer principle to SCs and STs, ensuring that the affluent among these groups are excluded from reservation benefits. And hence we can say it excluded the creamy layer within SCs and STs. In other words, to say, initially the so-called creamy layer and the related judgment by the Apex Court of India was given in Indira Shanai case, which is only applicable for the BC categories, backward classes. But now the Supreme Court clearly stated, like the way that the creamy layer is being applying for the BC category is the same way that it should apply for the SCs and STs as well. Not only that, the verdict also suggests restricting reservation benefits to the first generation, preventing prolonged reliance on quotas for families who have achieved social mobility. And hence we can say the Supreme Court clearly stated the generational limitations. Means, if the first generation is going to have SC and ST reservation, then the immediate following generation will not have this. And the third generation may have this, so that it can restrict the reservation benefits only to the first generation, so that preventing prolonged reliance on quotas for families who have achieved social mobility is the target. And finally we can say whether judicial review is applicable or not. And Supreme Court clearly stated that judicial review is applicable. Any state decision on subclassification will be subject to judicial scrutiny. Why? To prevent the misuse. Because there are n number of things that the states can take the arbitrary decisions which were driven by their political motives, and hence judicial review is must. And hence we can say that the court's rationale is rooted in the idea that some groups within SCs and STs are more disadvantaged than others among themselves. And this disparity needs to be addressed under Article 14 of Indian Constitution to create a tailored reservation policies for better upliftment of the marginalized groups within the community itself. So seeing this, understanding this, furthermore to continue, there are arguments for and against to this Supreme Court judgment. Especially we can say that the arguments which are in favor are enhanced equity, constitutional provisions and social justice, whereas the arguments against to this judgment are fragmentation of communities, risk of political exploitation and increased inequality. So here, when we are observing the favored conditions here, favored arguments here, this type of tailoring reservations for smaller subgroups ensures that benefits reach them most in need. It aligns with the constitutional principles of uplifting the socially and educationally backward classes. And that itself will become the true definition for social justice. Whereas on the other side, if you could observe the arguments against to the subcategorization and the Supreme Court judgment, especially the critics fear this could fragment the SC and ST identities, weakening their unified legal standing. And there is a lot of risk that subclassification could be exploited for political gain rather than genuine social upliftment. And hence, we can say data collection and empirical evidence is going to play a crucial role. It is going to play a crucial role in justifying the subclassification. To justify subclassification, states need to balance competing interests within these communities and ensure that policies do not create further division. But at the same time, you should also understand that it is going to create an administrative burden as well. The administrative burden of implementing subclassification policies is also becoming a challenge in this context, requiring significant resources and careful monitoring and review systems. So in this context, you should understand certain other points for our examination, where Article 14 of Indian Constitution can help to address these disparities, and this approach allows the states to tailor the reservation policies to more effectively support the most disadvantageous within these groups. In this context, you should also remember there are also references for the subclassification issue, where a 5-judge bench in the case of state of Punjab versus Davinder Singh 2020, or reconsideration of E.V. Chinnaya judgment versus state of Andhra Pradesh in 2004, where the Punjab Scheduled Caste and Backward Classes Reservation in Services Act 2006, especially the section 4 clause 5 of this act, making the provisions mandated that 50% of the vacancies reserved for SCs in direct recruitment will be offered to Balmiki's and Majabi Sikhs based on the availability. So you please do understand, it is not just the 14th article, there are also certain other constitutional provisions in this regard. And the most important constitutional provisions were like 16 of 4. 16 of 4 article of the Indian Constitution, where this provision permits the reservations for backward classes who are inadequately represented in state services. Likewise, we are also having Article 15 Clause 4, which empowers the state to create special arrangements for promoting the interests and welfare of socially and educationally backward classes such as SCs and STs. Likewise, 342 Clause A, which supports the flexibility of the states in maintaining their lists of socially and economically backward classes. So the homogeneity of SCs and STs, the uniform status of SCs and STs as recognized in the presidential list is furthermore being under the control of the states, where the potentiality for inequality concerns will rise, which further lead to a division and rise in inequalities within the communities. So ensuring that subcategories do not undermine the overall goals of reservation policies is crucial. Subclassification policies can face the opposition from political groups that either support or oppose the changes to reservation systems, leading to potential delays and conflicts as well. Because of which, on another side, this subclassification might increase the existing social tensions within SC or ST communities, leading to intra-community conflicts and divisions, which itself furthermore can trigger for the security of this country, for the sovereignty of this country as well. However, in conclusion, we can say the subcategorization presents both opportunities and the challenges. The opportunities can be seen under the arguments in favor, and the challenges can be seen in the arguments against to this. It has that potential to bring greater equity, no doubt, to the India's reservation policies. But at the same time, we must be very carefully managed to avoid the fragmentation and political misuse. So you as the aspirants must be aware of all these evolving legal and social frameworks, as they are crucial for both GS Paper 1 and GS Paper 2 preparations. So this is what all about the present current affair related to this topic. And here comes the practice question. Examine the implications of the Supreme Court's decision to permit the subclassification within SCs and STs, and how could this ruling reshape India's reservation policies and influence the socio-economic development of marginalized communities. Do develop an answer and submit the same if possible. Practice this, understand the concept, so that you can easily go through the examination preparations. That's it for today's video, and if you found this discussion insightful, don't forget to like, share and subscribe to our channel. Good luck with your preparation, and we will see in your next video.